come. Office objections are there, it will not come. If complied, it will come tomorrow.
My lord, one submission, my lord. In list number 2, my lord.
Tell him.
Lordships, I am for the petitioner, my lordships, seeking the custody of the minor daughter, my lordships. My lordships, the respondent husband
Which year is that?
24, my lordships.
Notice is ordered. Notice is served. Yes.
My lord, list number 2, my lord.
Sir, I will call list-wise assignment. Wait, sir.
Much.
Use the
English.
Fresh matter, my lord.
Hmm.
138 matter, my lord.
The trial court ಅಲ್ಲಿ
138 ನಮಗೆ ಬರಲ್ಲ ಸರ್. ಈ ಕಡೆ ಬಂದ್ರೆ criminal
Next.
case ಅಲ್ಲ.
19 next one. My lords, 2023 matter, my lords. We are ready for settlement. Petitioner is ready for settlement, my lords. Regarding 125 application.
petition ready, respondent also ready, that's all.
We have served them notice, my lord. If they appear, we will settle before the court itself.
List it on Wednesday. Yes.
Kind submission, my lord. It's an execution matter, my lord, for Reliance actually. We are for appellants, my lord. It's a fresh matter, and they already got execution order on execution petition 39 of 2024, my lord. Last month is the order dated, my lord. We just we filed it on last month itself, my lord. So kindly on tomorrow, my lord, because it's an last month itself the order date has been there, my lord, for execution. So kindly for tomorrow, my lord.
Which year is the writ petition?
It's
Writ petition which year?
yeah, MFA it's 25 fresh matter, my lord.
MFA. Oh, MFA. Yes. Tomorrow.
Okay, much obliged, my lord.
My lords.
Fresh matter, my lord, seeking for, the petitioner has seeked for divorce in the year of 2019, and they've been taking adjournments, paying fines, and continuing with it.
Pending matter, there was a direction to the respondent to pay the arrears amount. After service of hand summons also, they have not.
My lords, it's a pending matter, my lords. There is a stay in this matter, my lords. In spite of that, the trial court has passed an order for the spot sale of the said property tomorrow, my lords. Kindly have it tomorrow, my lords.
What is which
Classification.
what is that?
Classification, MVCD, MFA, my lords.
MFA MBC.
Attachment.
Attachment.
Tomorrow. Yes. Call the list.
Page-wise adjournment, list 1, page 1, cell number 2, 3, page 2, cell number 4 to 6, page 3, cell number 7, 8, page 4, cell number 9 to 15, page number 5, cell number 16 to 21.
Serial number 17, my lords. I appear for respondent in this matter, my lords. We have to file a memo for calculation in this matter, my lords, which is ready, my lords. We have to file it. Week time may be.
My lord, I've received the calculation today. I'll take the instruction from our client and
At the request of both the parties. This is the matter after.
as per the convenience.
After next week, my lords. Anyway.
List the matter on 21st of July.
Grateful, my lords.
Yes.
Thank you.
Page number 6, cell number 22 to 28.
Seal number 23, my lords. I have informed the other side. Need two weeks of combination.
I'm for the petitioner in serial number 23, my lords.
You have no objection.
No objection, my lords. Interim order can make.
The respondent. This is the matter on 22nd of July. Interim order earlier granted is extended till the next date of hearing.
Obliged.
Yes.
List number 2, page 1, page 2, cell number 2 to 5, page number
2, my lord. List number 2, first matter, my lord. Your lordship may have it tomorrow, my lord. There is a function at home today. Tomorrow, my lord. For final disposal, it is posted.
Not tomorrow. List the matter on Thursday.
Much
List number 2.
Serial number 3, list number 2, my lord.
Number 2.
My lord, list number 2, serial number 4, my lord.
My lord, I have
Mr.
sought for stay.
Somebody is asking for time here. Please wait. Yes.
Stay compliance, we have already deposited, my lordship. Acknowledgement I have to receive. So far, I have not received acknowledgement.
My lord, serial number 1, Thursday, my lord.
Sir, Thursday, sir.
Oh, much obliged, much obliged, much.
My lord.
Some time.
What do you want into?
I have to deposit the stay compliance, my lordship. As per instructions, they have already deposited, but I have not received the deposit, my lordship. That's why.
You submitted that. Already the statutory amount is deposited and he is yet to get the instructions or with regard to that. Let's this matter after 2 weeks.
16, my lord.
Page number.
Serial number.
Sir, page wise adjustment. Page number 3, serial number 6 to 10.
My lord, serial number 4, my lord. I am ready for argument in this case.
So why are you telling? If you are ready for argument, it will be
Please.
called.
Please, ma'am.
Page number 4, serial number 11 to 15. Page number 5, 16 to 20.
Serial number 16, my lord. All three matters, my lord. R1 dispense with, my lord. R2, my lord, BC Shivanagoda take notice. HDFC.
Which insurance company?
HDFC insurance company.
Mr. Shivanagowda is directed to take notice on behalf of the respondent, and the council shall have the copy of the appeal on the council appearing for the respondent.
All three matters, my lord. R1 kindly may be dispensed.
And the memo is filed. Dispensation of notice to R1 and the memo in all the matters. Memo is taken on record and notice to so and so is dispensed with. Admit post of final hearing. Call for the receipt.
Refer to local. Not admit, my lord. Refer to local.
Lok Adalat. Then we'll have it. Let it be in the list. Let it be in the list. In the afternoon, we'll see.
Tomorrow?
Tomorrow.
One matter, my lord, is a contributory negligence is there. That's why, my lord, better.
No, that's what I'm saying. What are you
We have it on day after tomorrow, madam. We will discuss and we'll come
today,
back.
tomorrow, and after tomorrow, court will be hearing
come
all the
back.
Lok Adalat matters. List this matter tomorrow in 2 o'clock list, 2:30 list.
Yes. Page number 6, serial number 21 to 25.
Next.
Next, list number 2. List 1, serial number 1.
What is the next list? That is Lok Adalat.
List number 1 for being spoken to, serial number 1.
My lord, in page number 6, my lord, there's a mistake in 2000 year, my lord.
One. Page number?
My lord, page number 6 of the order, my lord. The 6th line, my lord. Instead of 2013, my lord, it should have been 2018, my lord. Then in page number 7, my lord, just above para 5, 2013 is to be changed as 2018, my lord. His date of birth is 1658, my lord.
2018.
Then, my lord, in page number 8, my lord, just above para 6, my lord, the date of incident, my lord.
1 minute. Paragraph number?
My lord, paragraph number 6, just above para number 6, my lord, 12% interest from the date of petition, my lord. It is written as incident, my lord, petition. Then, my lord, in page number 9, clause 1, my lord, in the operative portion of the judgment also, my lord, date of incident to be, my lord, made as date of petition. That's all. I informed my learned friend also about the corrections, my lord.
Yes, ordered. Next.
Orders matter, serial number 2. Memo for withdrawal.
Appear for petitioner. I withdraw the matter.
Memo is filed seeking to withdraw the petition as the matter as the dispute is amicably settled between the parties. Memo is taken on record. And the same is the appeal is dismissed as withdrawn. Next.
Number 3.
For the respondent in this case, my lord. The proceedings in the trial court are going on at a very good pace, my lord. We need little more time. Cross-examination of the petitioner is done. Defendant evidence is pending, my lord. On 11th of August, she is coming here from Goa. Until 14th, she will finish her cross. If all goes well, my lord, we have one more witness. By
No,
August, we'll finish.
It is about a letter from the judge.
3 months should be good, man.
A letter is addressed to the 5th Additional Principal Judge Family Court seeking extension of time for disposal of MC number 833 of 2010. This court, by order dated this court had directed the family court to dispose of the matter expeditiously, but not later than 6 months. It is stated that now the case is fixed for cross-examination of PW2, and there are some other matters wherein timeline is fixed by this court. Hence, request for another for extension of another 3 months time for disposal. Considering the same, finally 3 months time is granted. No further extension will be granted.
Obliged, man.
Yes, next.
Cell number 4.
The matter has been settled, Your Lordship. I'm filing the joint affidavit with that. Both the parties are present.
Take that.
They filed a compromise petition before the court below, Your Lordship, in Mysore, in MC number 1205. The terms of compromise are in para number 5, Your Lordship.
It's already filed before the
Yes,
family
Your
court.
Lordship, the compromise petitions. The proceedings in criminal miscellaneous 958 of 2022 have become infructuous, Your Lordship.
Where do you get that about the withdrawal of this case, WP?
Yes, Your Lordship.
Where do you find that? E.
There was a stay given by this honorable court for the proceedings with the court below, Your Lordship.
The present writ petition is filed questioning the interim maintenance.
No, Your Lordship, for filing an additional document before
Where is
the
that?
court.
Where is the imprint order?
Main.
The present writ petition is filed agreed by the
1906
orders
it was
passed in I number 5 filed under section 65C of the Indian Evidence Act to receive the document number 1 to 8 listed therein as secondary evidence. That application came to be dismissed, agreed thereby. The wife is before this court. Today when the matter came up, the then counsel appearing on behalf of both the parties.
And for the husband, Your
Counsel
Lordship.
appearing for the petitioner submits that parties have already entered into a compromise, and a compromise memo is filed before the court. The respondent party is
The petitioner is the husband, Your Lordship. I am for the husband. Yes.
Anirudh.
Yes, Anirudh.
For husband is before this court, and the party, the wife is the respondent wife is also present before this court, and an affidavit is filed stating that they have entered into a compromise in MC number so and so, MC number 1205
1205
of 2024, and
2024.
amicably settle their disputes. Nothing survives for consideration in this petition, and they pray that to quash the criminal miscellaneous number 958 of 2022 as having become infructuous, considering the joint memo that is filed before this court, and as a disputes are amicably settled between the parties. No, you can withdraw this. Why should we? You can file a memo there.
Your Lordship, see, there was a stay given by this honor. Therefore, we
Well, as
come.
far as this is concerned, we can file a memo there. Before the court, this writ petition becomes infructuous.
May be quashed by this honorable court, Your Lordship. I'm seeking for a prayer for quashing the entire proceedings before the court below, Your Lordship.
You can file a memo same memo before the court in the light of the the settlement arrived on between the parties, this writ petition becomes infructuous and the parties are at liberty to file a memo before the court where the criminal miscellaneous is pending. Yes.
Your Lordship, I'm also seeking for the return of the documents, originals which
All
are
the
there.
documents, the document shall be returned to the petitioner. Yes.
Cell number
To the
5.
respondent, Your Lordship.
To the
To
respondent.
the respondent.
Fine, Medipa. What is it?
Obliged.
Why you have filed the petition? Why it will be returned to respondent?
Because the originals belong to her, you know, that.
You can give it to her. Yes.
Yes.
Cell
I'll
number
instruct.
5.
Obliged.
For the petitioner, my lord, in this matter, my lord, I have served the other side advocate before the trial court also,
Rectification
my
of the
lord.
office objections on the process memo filed by the council.
Uh,
That is custom declaration.
Some
What
declarations,
is that?
but I need to verify because the respondent is staying abroad, my lord. I need to verify the office.
2 weeks time.
Interim order
So
may
complying
kindly,
the office objections.
interim order may be extended, my lord.
Default order. Interim order earlier granted is extended till then. Next.
Cell number 6. Tatima SK for petitioner. Chichi Malail for
Lots,
respondent.
this is regarding the jurisdiction of the family court at Bangalore to decide a custody petition filed by the wife.
Direction
The
by this
petitioner is
honorable
the
court to
husband.
comply this office objections, my lord.
No, office.
Last date there was in a direction.
Milas, let me clarify. The office
What are the
objection.
office objections? Let's see.
Milas, office objection is regards with the objections filed by the petitioner herein, who is a respondent in GNWC before the family court. There is no objections filed by him at all.
Memo for correction in the typographical error of.
Milas, everything is complied except this, and they want us to submit before your lordship.
You know what is, I'm not able to understand this. With regard to pending office objection, kindly posted before the court. What is the pending objection? Objection to?
The objection is
petition
the
to
main
be filed.
petition.
It is not filed, then what they can, where from they can
No,
file?
no, my submission is that there was a direction by this honorable court in respect.
The office objection is to file the objections to the petition before the trial court. And counsel submits that no such objections are filed. Accordingly, the office objections are overruled. Yes.
Great. Plus, this is, plus, may I?
Yes.
Plus, this is the father's petition questioning the jurisdiction of the family court at Bangalore to decide on a custody petition filed by the wife. Plus, the parties were residing in Pune from 2011, from the time they got married. Thereafter, my lords, a child is born in 2014. She goes to her place in Rajasthan for the delivery, of course, and comes back to Pune. Child from 2014 all along has been residing in Pune.
Till when?
My lords?
Till when?
Till 2024, last year. She was admitted in a school, studying there. Father was paying all the expenses, everything. Now, suddenly, my lords, in the month of April, during the vacation of the child, the mother brings the child to Bangalore and thereafter files the custody petition before the family court at Bangalore.
When she came to Bangalore?
Miller, she, exact date, we do not know because she never told where she is in fact.
No. You know the exact date when she left the home?
No, she left the house 18th April.
18th April. When
April.
is this petition filed?
28th June, my lords. 28th June, she files this. Thereafter, notice comes to the petitioner father. When he appears.
Let us see the petition.
My lords, at page, end page is at 334. However, it starts with 22 ink page, my lords, annexure F. May I just take your lordships to the last page, which is which will be relevant, my lords. 31. Plus, I think 30, I would start from there. The petitioner submits that cause of action arose on 12/2/2011 when the marriage of petitioner and respondent took place. Then on 22nd, when they started.
Are you reading?
Milos, 30, para 30, 33 page number. Last, Milos. The petitioner submits that cause of action arose on 12/2/2011 when the marriage of petitioner and respondent took place, and on 22nd April 2024 when they started living separately and is continuing uh, till date. Then 31, since the child is residing in Bangalore, this honorable court has jurisdiction to try and dispose of the matter. That is all. During the vacation, summer vacations of the child, she just leaves after a small disagreement and a fight. In fact, the whole family was supposed to go on a vacation. She does not say where she goes. And he gets to know that she has gone to the parents' place in Rajasthan.
Where from this Bangalore has come?
She
Because here-
subsequently comes and starts residing in Bangalore and files.
For that, we will see what she says in the preceding paragraph.
Yes,
With
Milords.
regard to what has transpired.
Milords, nowhere she says.
From 24th April. Where is the reference to 24th April?
Milords, regards that, 20th,
Come to
Milords,
paragraph number
20th,
18. Paragraph number 18 and read.
18, okay. The petitioner submits that in the month of January 2024, she requested the respondent to equally contribute towards the household expenses as she was getting financially overburdened. The respondent draws handsome salary of 60 lakhs per annum. Respondent apart was also getting income of 22,000 monthly from house. They had let out on rent. After the repeated requests and pleadings, respondent could transfer the amount to petitioner's account. Further, whenever petitioner asked for money to meet day-to-day expenses, the respondent would scream at the petitioner. All these incidents happened in the presence of their minor daughter.
Yes.
It is pertinent to note that after every such incident, petitioner's minor daughter would express her pain to petitioner saying, "Why can't we have a normal life like my friends have?" Further, 19th paragraph. The petitioner submits that on 17th March 2024, the petitioner's friend by name Suprabha, along with her 10-year-old son, came to petitioner's home at Pune in order to invite the couple for a son's birthday party. During such time, respondent was angry at the petitioner for spending money on cab and food expenses during the time of her recent outings to movie and malls along with the daughter. It is pertinent to mention that the respondent neither took out the petitioner and the daughter, nor was he happy with petitioner going out with the daughter for an outing. The respondent vented out that anger to petitioner's friend in front of her son and their minor daughter. He started cursing the petitioner saying, "She's wasting money on outing. She would soon fall sick and get bedridden for 6 to 7 months. He verbally abused the petitioner in front of a friend. Petitioner's friend was scared due to such behavior of respondent and left the place immediately. 20 Milords. The petitioner submits that on 18th April, respondent took a week's leave from work and petitioner was working. As the respondent was free at home, he started fighting with the petitioner on silliest issues and was interrupting in the petitioner's work. When the petitioner requested him to move to a different room as she was unable to concentrate on her work, this enraged the respondent and started physically harming the petitioner. The respondent sat on petitioner's legs, even though he was very well knew that she was suffering from arthritis. The respondent harmed the petitioner by twisting her hands out of anger. He abused and cursed the petitioner. "Why don't you die?" every time you return from deathbed. This incident was life-threatening to the petitioner, and anything could have happened. While both the parties were fighting, their daughter was attending her online Kathak class, and all these abuses were audible to her class. She was so upset that day, the petitioner was shattered by the incident. Then the petitioner submits that subsequent to the said incident, the petitioner's knee pain even more increased and it started to create fear in her mind about her safety. That apart, such behavior of respondent was causing mental pain to petitioner's daughter. Hence, the petitioner was forced to leave her matrimonial house. On 22nd April, petitioner along with the daughter traveled to her parents' place at Bundi in Rajasthan and stayed there for 15 days. The parents were shifting to Bangalore to her brother's house. The petitioner decided to move to Bangalore to her brother's house. As it was not safe for her to stay at Pune alone with her daughter, as the respondent's family is highly influential. Accordingly, on 8th May 2024, the petitioner traveled to Bangalore and stayed at her brother's house. Subsequently, during the month of June 2024, she rented a house at Hebbal for herself and a minor daughter. The petitioner submits that on 24th May 2000.
Yes, I've seen.
This is the.
Now come to the impugned order.
Well, it's at page. May I go to the last relevant para, page 50? It starts
No, what are the reasoning given by the court?
Reasoning.
Come to point number 1.
Let's Point number 1, 58, my lords. Petitioner has filed this petition against respondent under section so and so to declare that she is the sole guardian of a minor daughter by name so and so for granting permanent custody of a minor daughter. Admitted facts are that petitioner is a legally wedded wife of the respondent. Out of the wedlock, their daughter is born on 19/1/2014. Originally, the petitioner was a resident of Rajasthan and the respondent was a resident of Madhya Pradesh. Until 22/4/2024, the parties were residing in Pune along with their child. Now the petitioner is staying in Bangalore along with her child and got admitted her child to Vibgayar school. Petitioner is contended that the respondent ill-treated her before the child. And since his ill-treatment was intolerable, there was threat to her life. She left the matrimonial home in Pune, went to her parents' house at Rajasthan, and stayed there for 15 days. Since her parents were planning to move to Bengaluru to settle with her brother in Bangalore on 8/5/24, the petitioner and her daughter came to Bangalore and stayed in her brother's house for some time. And thereafter, she started to reside in a rented house in Hebbal of Bangalore along with a minor daughter. Learned advocate for petitioner has vehemently argued that since the child is studying in Bangalore along with the mother, this court has got territorial jurisdiction. On the other hand, the learned advocate for respondent has argued the same vehemence that ordinarily residence of the child is Pune and she was studied in Pune and hence this court has no territorial jurisdiction. That's all along from the birth of the child stayed in Pune along with the parents. Child was admitted in a school in Pune. Even during the vacation time after the vacation, the father has admitted the child to the 5th standard in Pune. Now in vacation, 18th of April, she leaves Pune for her own selfish reasons, goes for some days to the parents' place at Rajasthan.
What do you say about the finding of the court? What do you say about the observation of the court?
Well, its ordinary residence is in Pune. It is not at all in Bangalore. Just because the wife intended.
Lordship, may kindly see, this matter was argued before the previous bench in length. Finally, the reason is, Lordship, may kindly see, husband is also filed a GNWC petition before Pune court. Subsequent to this, almost after a year, after the hardly contesting this matter, thereafter he goes and file a petition. Now the matter is stayed by the apex court, the Honorable Apex Court in terms of matter before the Pune court. So this same argument was made before the previous bench. And court also suggested, since a jurisdiction regarding the thing, if it is matters that transferred, it will come here. Always this automatically that is allowed, this automatically will go back. Till then, let the matter be pending for this Honorable Court. That was a consideration. Thereafter, they said they wanted to visitation application. They wanted that to be considered.
So why this case can't be decided independently?
Lordship, may kindly say there is his violent behavior. See, Lord.
No, please understand this.
Now she shifted to Bangalore.
She might be. She might be. When there is when this application is filed, and under section 9 of the Guardians and Wards Act, ordinary place of residence has been interpreted by the Apex Court and this court in several judgments. At any stretch of imagination, the courts at Bangalore has no jurisdiction. Now you say that there are so and so reasons. You should have filed a petition in Pune, wherever they were, and you have the compelling reasons about whatsoever. You should have filed a transfer petition before the Honorable Apex Court and could have got it transferred to Bangalore. Now, this kind of interpretation we cannot let the courts give.
No, mine is the first petition, my lord. I filed it in
Not
Bangalore.
about first and second application. You have to consider
No,
section
by
9
the
of
time
the
shifted permanently to Bangalore, my lord.
ordinary. Just shifting from one place to the other will not become an ordinary residence. That's what consecutively Supreme Court has held in umpteen number of cases. Now it has now in all these custody matters, this has become a big problem. If the courts and even these family courts also should pass immediately the order whenever this jurisdiction issue is raised. Even on a clear reading of your petition also, courts at Bangalore have no jurisdiction.
No,
at any term, it can't be termed as ordinary residence of
No,
the
my
man.
lord, it's not daughter. She's studying in Bangalore.
Who?
Child is studying in Bangalore.
When?
From since May.
May of which year?
Sorry, date of thing,
May of 2024.
24.
And,
Before filing of the petition itself.
May of 2024. And your petition is on July.
July, my lord.
June. So how can it become an ordinary residence?
Lord Simeke, that is what this Apex Court judgment also into that.
There is a
effect.
judgment, please go to
That
the
has
court.
been cited, my lord.
There are so many other judgments contrary to this, because the other day I was dealing with it. There are a bunch of judgments contrary to what you are saying. Whenever the disputes arose between the parties, just like the taking away the child and filing the application for GNWC, court will not get jurisdiction. Yes, let us see. Which page?
Para number 8, my lord.
Yes.
Is not, may I read, my lord?
Yes.
It is not in dispute that child is now residing with
Para
his
8
father.
starts with having heard.
Para number, ink page, ink page number 8, my lord. Internal page number 8, para number 9, my lords. It is not in dispute that the child is now residing with his father at Belgavi. Whether Belgavi can be considered as the ordinary place of residence of the child in question. Honorable Court so and so. It is evident from the bare reading of the above that the solitary test of determination of jurisdiction of the court under section 9 of ordinary residence of the minor. The expression used is where and the minor ordinarily resides. Now, where the minor ordinarily resides is a given place in primarily a question of intention, which in turn is a question of facts. It may at best make mixture of question of law and the facts. But unless the jurisdiction facts are admitted, it can never be a pure question of law capable of being answered without an inquiry into the factual aspects of a controversy. The factual aspects of relevant to the question of jurisdictions are not admitted in instant case. There are serious dispute on those aspects to which as well separately refer. We may, before going to examine its true purpose of examination, ordinary residence appears in section 9.1 supra. This expression has been used in different contexts and statutes and has been often come up for interpretation. Since liberal interpretation is the first and the foremost rule of interpretation, it would be useful to understand the literal meaning of the two words by comprise the expression. The word ordinary has been defined by the black so-and-so. Ordinary, regular, usual, normal, common, often recurring, according to the established order settled, customary, reasonable, not characterized by the peculiar or unusual circumstances belong to the existence of characteristics of the normal or average individual. The word reside has been explained similarly under the reside, live, dwell, bide, short, stay and remain long. To settle the oneself for a thing in a place, to be stationed, to remain or stay or dwell permanently or continuously, to have settled about for a time, to have one's residence in domicile, especially to the residents to have a abiding place, to be present at the element, to inherence in the quality to the rest of the right, to dwell for a considerable time, to make one's have life, to exist and attribute to the or qualify with, to be the best within. In the same judgment reference to so and so,
several judgments of the Supreme Court
denote that the word ordinarily is primarily directed not to duration but to the purpose. In this sense, the question is not so much where the person is to be found ordinarily, in the sense of usually or habitually and the some degree of continuity, but where the quality of residence ordinarily and the general rather than merely for some special limit purposes. Lord Lordship can say, I'm working here, I took up a house here, I have admitted the child to the school, and after Lordship can say, this was never been, she is completely abandoned after while series of, because I'm not, it's a GNWC petition, I have not narrated the length and breadth of what are the things I have been gone through for the past 15 years. That doesn't mean that nothing has happened. Lordship McKinley, these circumstances because her family, there are a lot of police officers and a lot of other influential persons in Pune. My life itself, my contention is Lordship McKinley, he's a violent, very, all of a sudden he become a very, has a split personality. One side he has a good, very sweet and nice person, all of a sudden he completely violent in nature. This is the characteristic in which I was facing throughout. Now, Lordship McKinley, I've decided, I came to Bangalore, admitted the school, child is studying in the school throughout, the year. Thereafter, almost child was completed the education first year, then they filed this application before the Pune court. It's not that they, only for the purpose of just.
So you admit that immediately after coming to Bangalore, within 2 months, you have filed this petition.
Please, my lord.
And
No,
you
that
call
is
it
also
a-
lordship make
you call it the ordinary residence of the minor. And you're taking a shelter on the judgment of what you have cited.
Please, my lord.
There are several judgments of the Supreme Court where they have interpreted what is an ordinary place of residence of a minor. That you please look at it. I'm not.
I will also look at that and make a submission
There are
on that.
several judgments which
Please.
goes, no, this is the biggest problem in the GNWC cases. Even the parents who are leaving abroad, just like that one fine day, the children are brought to India and the other parent will be in US. They'll file a case here for under the GNWC petition here and say that no, I've joined the child here. It becomes his ordinary place of residence. No, it will not. And this is and these kind of cases, the courts have to be very strict on this. And if you feel that, first of all, when the act prescribes what is an ordinary place of residence, all through for years together when he was residing there, you file a case, a GNWC there in whichever place, the Pune, when you feel that these are all the reasons for which you have threat to your life or you are working in Bangalore, then and the minor is residing with you, then you can file a transfer petition in the Supreme Court and get it transferred to Bangalore for the compelling reasons. So when the act is very clear, when section 9 is very clear, we cannot interpret in any other way.
No, lordship
Please look
make
at it.
No.
Please look at the judgments. All the judgments are against you. I am telling you. This is matter day after tomorrow.
Not day after tomorrow, ma'am. Maybe I'm a traveling man. Maybe next Tuesday, my lord.
Plus,
Yes,
may I?
next Tuesday.
Plus that would be, this is exactly what has been happening. May I request for a shorter date if you're
I'm
lordship?
traveling. That's a
Because
reason,
I'm
specific
not-
reason.
Tomorrow then.
No, tomorrow is very short, my lord. Wednesday, I'm
I have all
traveling.
the judgments, I
I'm
can
not
share
asking.
it even afternoon.
Tuesday, I will do Tuesday, following Tuesday. Monday, I'm back. Tuesday.
Great.
This is the matter on Tuesday, the request to plan counsel for the respondent.
Number 7. 7 S. Naveen Kumar for petitioner Suhas G for Kevita respondent.
The copy was served to the respondent.
Non-compliance of office objections.
Appear for respondent. But this connected matter was disposed of on Thursday, my lord. The petitioner counsel has asked for clubbing of this petition, my lord. Accordingly, our lordship was asked to.
Yes. Office objections to be complied. This is the matter.
The office objections also that.
Please comply, whatever it is. Once the office objections are complied, then list the matter.
Kindly date may be fixed by any.
You do it today, it will come tomorrow.
By next week, please. Only 1 week.
Date.
Finally, a week's time is granted for complying with office objections. Yes,
Please.
next.
Extremely sorry, in that interim order I forgot to make.
In earlier matter, interim order is there extended till the next date of hearing.
In 8.2, there are office objections. I will comply with it. Three matters.
What is this criminal RP?
No, but that was clubbed with the RPFC matter. That's for it has come out. But in 8.2, there are office objections. I will comply with it in a week.
Office objections to be complied with within a week, default order.
Please, members.
Till number 9.
My lord, I have compared the interim direction of this one, my lord. I have deposited the amount. I have filed a memo on.
How much was the amount granted? How much this court has?
My lord, these are 10,000 per month, my lord. I have opened the account in the name of my son, and my lord deposited 10,000 each, and the account details also furnished by memo dated 2/7/2025, my lord. My lord, I request my lord senior today, my lord.
No, you deposited, they need to withdraw it.
My lord, let them withdraw. It's always so.
What was the amount?
10,000 immediately.
What was the amount
My
that
lord,
was granted by the?
in compliance, the order dated 1/2.
Mr. Counsel, please hear what I am saying.
Please.
What is the amount that is granted by the family court?
My lord, family court has awarded, my lord, 50,000. And this Honorable Court has stayed that order and permitted me to deposit 10,000.
Where is the order? What is the reason for
My lord,
reducing that amount?
order dated 1/2/2025, my lord. My lord, 1/2/2025.
Yes, please come to the order.
Please, my lord. Heard learned counsel for the
Not
petition.
this order. Please come to the impugned order. Why 50 to 10? At least it should
My
have
lord,
been
my lord,
25.
no, my lord, what,
That's why I will look at the impugned order.
please, my lord,
come
my
to the
lord,
impugned
what
order.
happened, my lord? No opportunity has given to the
Let me look at the impugned order.
my lord, please, my lord.
Please come.
Please. The petitioner
Why
filed this
opportunity, according to you, opportunity not given means?
opportunity for my lord, my contention before the honorable court below, my lord. She is working, she is earning more than 40,000, my lord, before because she is working as a, my lord, professor in the college, my lord. We are living together, my lord. We are living together. She is also working. I am also working. My salary is, my lord, 45,000 rupees, my lord. Her salary around, my lord, 40,000. That is my.
No, 45,000. How can the court ask you to pay 50,000?
That is why, my lord.
Come to the order.
Please, my lord. Only taken contention of the respondent, my lord.
Come to the order. We'll read.
Please,
and
please,
then
madam.
you can
Please,
make your
please, madam.
submission. Come to paragraph number 9.
9, madam. Please, madam. Please. The petitioner filed assets and liability. On perusal of the same, it shows that due to wedlock of petition number 1, respondent number 1 male child, namely Advait A, was born. Further, the said child is having genetic issue that is detected and need of more diagnosis of thalassemia. Further, it shows that the child is in custody of both petition number 1 and respondent, but respondent number 1 is not aware of expenditure for maintaining the child. The said child is 3 years old and requires 26,000 per month as a school fee. 50,000 discount till February 24 is to be deducted as it is allowed by the school manager as kid is the first child for a school and concession from changing.
Why
from
did you not
preschool.
file your statement
Further,
of assets and
my lord,
liabilities?
why, my lord, my lord, on the day, your lordship may kindly peruse the order sheet, my lord. I have produced.
Not, where is that?
My lord, one submission, my lord, at page number 78, my lord.
No, before-
Typed copy, my lord, because it is
Go
in the
to
handwriting. Yeah.
Before I go to page number
Please, ma'am.
78.
Please.
When was the IA filed?
My lord, IA filed on, my lord, assets and liability, my lord, the petition, annexure, my lord, annexure F at, annexure F, my lord. Dated 8/11/2023, my lord.
When did you enter appearance?
My lord, I have appeared on, my lord, service held sufficient on 21/2/2024, my lord, held sufficient, RP edition.
Then when is this impugned
Then
order?
I filed wakalat, my lord. I placed expert and then recalled, my lord, on 30.
When is the impugned order?
My lord, impugned order passed on 11/7/24, my lord.
So,
My lord.
this
My
time
lord,
is not
impugned order,
sufficient.
sorry, my lord. Impugned order passed on 21/8/2024, my lord.
So this
My
much
lord,
time is
your
not
lordship may
sufficient.
kindly peruse the order sheet, my lord. One submission, my lord.
No.
My lord,
You entered appearance when
my lord,
already
my
IA
lord,
is served on you.
my lord, one submit, my lord. One submission, my lord. Your lordship may kindly peruse page number 78, my lord. Page number 78. On 33/2022, CNS files power for respondent. On 33/2024, I filed along with 311 and objections to provide fair opportunity, and cost of rupees 1,000 objection taken under. Respondent dares to file affidavit of assets and liabilities with the documents on next date without file, my lord. My lord, on 33 and 25/4/24, no sitting, my lord. And 8/7/2024, now it's 6 p.m. due to lack of time, case adjourned, call on 11/7. On 11/7/2024, my lord, my father was hospitalized. I have to take care of him, my lord. I could not appear before the court, my lord. And I request, my lord, I have applied for the, prepare for producing.
You're not well. What happened to your counsel? Counsel will file.
Madam, sorry, my lord, the assets and liabilities, my lord, I am even ready to file, my lord. Assets and liabilities, there is no difficulty at all. The difficulty is, my lord, no, I request, my lord, this before the and taken for as a nil and posted for, my lord, arguments of respondent.
Rightly did. Why should the court wait for you?
My lord,
Now this court has.
my lord, I am not blaming on the court, my lord. I request, my lord, because that is the stand taken by the
The court has lot of work, not alone your
My
case.
lord, my lord, I'm not going for that, my lord. My lord,
per
I'm
the
on the
judgment-
merits, my lord.
As per the judgment of Rajesh versus Neha, if you don't file your statement of assets, court has to take an adverse inference and court has taken and passed. I do not find any reasons to
My lord,
interfere.
my lord, one submission, my lord, one submission, my lord, one kind indulgence of this arm of court, my
Why
lord.
should we?
My lord, I request, my lord, you, if,
First of all, notice
my lord,
serves.
my lord,
You will set
my lord,
you have said you have been set ex parte, then you file a petition, then you will contest the matter, then you seek an application that is filed in
my
the
lord,
month of May 20.
my lord, I have produced my salary certificate before this honorable court. I have also produced her certificate, my lord. She is earning, my lord, my lord, my lord, my amount, my lord, I am earning only 45,000 rupees, my lord. And the honorable trial court directed me to give 50,000 rupees, my lord. I have to take care of my father and my family and also my lord. Therefore, my lord, I request, my lord, this interim arrangement may kindly extend, my lord, and fix the date before the trial court, my lord. I'm ready to cooperate. I will not, my lord, I request, my lord, because my lord is the extraneous, my lord.
With
The
your
order,
case,
my lord.
if you don't listen to the court, there is no, you're
My
not
lord,
going to get
my
an
lord,
order.
my lord, I'm,
First of all, listen to what court is saying.
please.
I will not interfere with this order because everyone who doesn't even file their statement of assets and liabilities before the court come to this court and say that court has not given time or I have not filed. So again, it has to be reconsidered. Court's time is very valuable. Already time is wasted there in the trial court. Again, this court will not waste the time. And if somebody do not file their statement of assets and liabilities, they are doing so at their cost.
My
And
lord,
this court will not show any kind of indulgence in these
my lord,
matters.
my respectful submission before your lordship.
I'll
After
record.
hearing both sides, my lord, this honorable court by granting interim order, my lord, granted, my lord, to deposit. I have deposited. I am not, my lord, because he is my son, my lord. I am not, my lord, my responsible submission, my lord. I have to give fair opportunity to produce my lord. Only 2 months, my lord, for assets and liabilities. When my father was hospitalized, my lord.
IA for interim maintenance has to be disposed of in 1 month. That is the
My
direction
lord,
of this court.
my father was hospitalized, my lord.
I'm
My
not
lord, I
interested in
request,
Mr.
my
Khan.
lord. I request, my lord. I request today, my lord. This is my senior wants to argue this matter, my lord, to produce the citations, my lord, because my lord is going to ask for my lord compliance of the order, my lord, for depositing the amount.
This
That is,
10,000.
my
If
lord.
the boy is suffering with what is that disease?
My lord, I am taking
10,000 will be
care.
sufficient.
My lord, I am taking care of him. He's both wife and son is with me.
No, my
They're
lord.
staying
He
with
is
me.
not taking. He is
My
not
lord,
taking.
she
He is
is
not
also
taking at all, my lord.
He is also admitting,
Just
my
he is
lord.
only, my lord. It is submission what my friend is submitting.
This matter tomorrow for judgment.
My lord,
Court will
for
hear
the argument.
This court will hear the arguments of the learned counsel appearing for the petitioner tomorrow and will pass orders
Please,
tomorrow. Come.
tomorrow.
10,
Madam,
Tilmali hearing 10, Sukanya.
9th, madam.
Interim order, my
Kindly have it on 10th, madam. Tomorrow I have some other.
Release the matter on 17th.
Interim order, my kindly.
Interim order earlier granted is expected.
Great.
Only now, the interim order, my lord, only is 10,000, my lord, in the.
You can't have both, Mr. Counsel. When I say tomorrow, you say after 10, some other day. And when the matter is adjourned, you say again about 10,000.
Sorry.
Cell number 10,
Appear for the petitioners.
Kanya Balika B.
Appear for the petitioners. Lord, this is a petition filed by the husband challenging the interim order on I number 4, which has granted about 20,000 as an interim maintenance to the child, and also in a 60-40 ratio. If your lordship is pleased to
You're
take
seeking
phase one.
enhancement.
Please, my lord.
You're seeking enhancement of maintenance.
No, I'm the husband, my lord. What has happened, my lord, in this matter? 2017, she
What
left
is
the
your
house.
salary?
Salary, I filed the asset and liability
You can
report.
tell the court. We don't have to look at it. What is the salary?
About 2 lakhs per month.
2 lakhs per month. How much the court has granted?
20,000, my lord.
That is also according to you cannot pay.
No. The facts and circumstances under which this has been filed, my lord. The IA, if your lordship may see, is filed under section 24 of the Hindu Marriage Act, which only provides for the pendente light expenses and things. But in this matter, the child's maintenance and the arrears of maintenance has also been awarded from the date of application, which is kept pending for nearly 19 months. I filed the petition. The separation is in 2017.
Then the court should pay for that, keeping the IA pending, that arrears court will pay.
No. What my submission is, my lord, from 2017, the wife did not claim any maintenance towards herself or the child.
When did she file the application?
She filed the application in 2023 when the matter was posted for chief examination and
So
cross-examination.
now we will clarify that arrears should be from 2023 and will not interfere with this 20,000 when you are earning 2
No,
lakhs.
arrears from 23 has been ordered to be paid, my lord. This is a petition filed by myself for seeking divorce in 2020. There's a separation from 2017. She is also employed as a software engineer. And 2020 to 23, I suffered for getting the summons served in the matter. Then I laid the evidence, I complete the chief examination. At that stage, she files an application for interim order. And also she has filed the statement of objections claiming 5 crores in alimony, which is not at all possible for payment. And also mediation was also failed. All these things happened. And thereafter, at the time of cross-examination,
Petition is permitted to take out hand summons on the counsel. I pray for the respondent.
may I pray for a stay of the order,
Once
my
the
lord,
memo
because
is filed, this is the matter. No.
Cell number 11, Vinod Prasad.
Yes.
This is the second round of litigation. Second round of petition. 2025, there was an order of 5,000 rupees per month. I have challenged. In page 19, ink page, we have filed a joint petition wherein it was agreed that I should pay her 3 lakhs. Well and finally.
Where is impugn order?
Ink page 19. Para number 9. If I pay 3 lakhs
Order is not at page number 19.
then that writ petition was rejected on the ground that it is my duty to maintain her without considering any of the
Page,
parts.
impugned order page number.
Interim order, now the order is passed at page 119. A short order. The petition 118, the petition under section 125 CRPC cannot be dismissed without full-fledged trial so and so. Now today there is an evidence. Now every time she files an application to arrest me, police come 4 o'clock.
I'm not able to understand what is this order, what is the implication of it? What is the application that you have filed before the court?
Well, Madam, what I request now is, let the petition itself be disposed of within under 2 months. Till such time shall not give mental torture. I have no money to pay her. My house is sold for nearly 36 lakhs with her. The sale deed is at page 31. My house she has sold.
Let the respondent come, notice the respondent. Petition is permitted to take out hand summons.
May I make one request, madam? Let them not precipitate to arrest me behind bars.
Cell number 12.
Otherwise,
Once the
very-
memo is filed, list the matter.
Only request, my lord, is
I do not find any reasons to stay it.
now what I request at the direction to dispose the main by another 2 months.
No, for that also, they are saying that you are not paying the maintenance and they want to strike off your defense.
No, 1 lakh I have paid. 1 lakh because I was arrested, I have paid 1 lakh with great difficulty.
Yes, once the memo is filed, it will be listed. Next.
Cell number 12, Pratima escape of petitioner.
Yes, what is this?
Plus, this is regards the visitation rights of the child. Plus, from the time of birth of the child. Plus, the difficulty is, let him come to the apartment for about 11 years. He's not seen the child at all, my lords, after throwing them out of the matrimonial home in Mumbai.
We'll see once the notice, same memo to be filed, once the memo is filed, list the matter. Yes, 13.
Plus, may I just ask for interim order subject to he coming and seeing the child in the apartment at least, because he's not even paid 8 lakhs maintenance, not a rupee has been paid.
What is the order on maintenance, on visitation?
Visitation is Sunday, morning to evening. He can take to the park or something, not park, mall.
No, according
Instead,
to you-
if he can just acquaint with the
No,
child.
He's not even coming according to you. So what is the interim order now? Let them also.
I know, but suddenly he turns up and then
Let them come. We'll not.
I'll
pass
serve
order.
the council.
Yes,
my lords.
yes, and file a memo. Once memo is filed, it will come.
Great.
Yes, 13.
For the petitioner, my lords.
Yes.
Petitioner's writ petition, my lords. Petitioner has filed a application before the trial court seeking the amendment of the pleading, my lords, to incorporate that petitioner is not a biological father of the.
Where is the impugned order? Come to the impugned
Page
order.
number 47, my lords.
Please come. Please read the order.
The
You filed an application on order 6 rule 17.
Yes, my lords.
That is dismissed.
Yes, my lords. It was dismissed on
What
the,
is this MC? MC is filed by whom?
by the husband, my lords, on the desertion and cruelty ground, my lords.
Wife files an application on order 7 rule 11.
My lords?
Wife files an application on order 7 rule 11.
Yes, my lords. And I have filed an application under 6 rule 17, my lords, seeking amendment of the pleadings, my lords, to incorporate that the petitioner is not a biological father of the respondent's child, my lords. The petitioner and respondent were together only for the period of 2 months, my lord. The respondent was not at all ready to lead a matrimonial life with the petitioner, my lords, at any point of time. She always wanted a divorce, my lords, thinking that as she was always ready, this issue was not raised in the
What
main.
is this? Can you, by way of an application seeking amendment, can you raise these kind of grounds? Altogether, setting up a new case. Court was right in rejecting this application.
No, my lords, the court has stated that it would amount to the withdrawal of the admission, my lords. Nowhere I have admitted.
You are not even denied. You said
I
that.
have denied in my evidence, my lords, kindly. In my cross-examination.
MCs of which year?
My lords?
MCs of which year?
22, my lords.
When did you file this IA? At what stage?
At the evidence stage of the respondent.
Yes, please come. Agreed with orders passed in I number 8 in MC number 5246 of 2022. Dated.
My lords, they've not even filed their objections, my lords, kindly.
Dated.
In my evidence, I've clearly.
Because they have not filed your objections, court just like that will not allow this kind of application.
I understand, well, I've nowhere admitted that the child is mine, my lords. In my evidence, I've clearly stated, my lords, it is not my child.
Dated 3/5. What is the date of order?
My lords, kindly pass on, my lords. My senior will come.
Tomorrow.
Cell number 14. Bindu U for petitioner.
In the connected case, your lordship already issued notice, my lord, in WP 18425. That was in matter.
So and so. Notice to the respondents. Yes, next.
Ma'am, your WP connected number?
18425. 18425 of 25.
Cell number 15.
Yes, next.
Petitioner is a husband, my lord. This is the wherein he has filed this petition for seeking direction to dispose of the MC within 6 months.
Which court is this?
The family court, my lord, Bangalore, 4th additional, my lord.
Here?
Here is of 2017, my lord. The lordship may kindly see.
The present petition is filed, seeking the following prayer. It is submitted that the MC is filed in the year 2017 and the same is pending on the file of the principal family court at Bangalore. This MC pertains to the year 2017, considering the fact that this pending from the last 8 years and already the directions are issued to the family court to dispose of the matters till 2019 expeditiously. This court deems it appropriate to direct the so-and-so to dispose of the matter within a period of 4 months from the date of receipt of the copy of the order. The notice to respondent same, as the disposal is in the interest of both the parties. Yes, next. Yes, next.
Number 16 for admission matter.
For respondent matter. Yes.
My lord, import order is the ex parte order, my lord. My lord,
From 2021, I shifted my present address, my lord. She has mentioned the previous address, old address, and she has filed a present petition and got the export order, my
How
lord.
did you know about this order?
I shifted in the year 2020,
How did you come to know about this order?
2022, my lord.
Huh?
22.
Where is your,
Provides the
where is
document.
your affidavit in support for the delay and all in this?
Yeah.
Let us
Page
understand from that.
27, my lord. Page number 27. I have mentioned in para number 6, my lord.
27.
Yes, sorry, 28, sorry, my lord. 28 page number, para number 6, my lord.
Hmm.
I have produced the document also, my lord, page number 21.
What are the other cases pending between you and the respondent?
No other case, my lord.
No other
No,
case?
my lord. One case is pending in family court.
What is that case?
That's for maintenance itself. And the miscellaneous 1110/22 and SIM is 357/23 is pending.
What is this?
This is yeah, on the order of the maintenance.
Minor
appeal.
son, minor son.
Minor son.
Hmm.
And this in the objections filed in para number 16. He has come, I have filed the recovery petition under 125 on the same address. So he has come to know that. No, and I also filed, I have no objection to allow this, but on the condition that intentionally he has avoided this. The preliminary matters of year 2015. From 2015, I am running in the
What
courts.
is your income?
My lord.
What is your income?
Nothing, my lord. He is a daily employee and he is employee in the one of the real estate office, my lord. And he is getting minimum wages, my lord.
That you don't, that also you will not specify. What are minimum wages according to you?
Minimum salary, my lord.
What is the submission, Mr. Counsel? When you're representing your client, are you not supposed to tell the court what is your income? First of all, you don't contest the matter. You come here, you don't file your statement of assets and liabilities, and you say, well, minimum wages. What are minimum wages?
I'll collect the information, my lord, regarding the income of my client, please, my lord.
What is, there is an interim order of stay?
Interim order of stay.
Interim order.
Stay, you can
No,
come.
my
you
lord,
can
I am
come
paying
conveniently.
maintenance every month 3,000 to the minor son, my lord, as per the order of this honorable court, my lord.
My lord, there is no totally, yesterday night they have transferred 15,000 and still 5 months maintenance pending.
That is at 3,000.
3,000.
15,000.
Ah.
As per the interim order passed by this court, when counsel for the respondent submits that an amount of rupees 15,000, there are arrears of an amount of rupees 15,000, the same shall be paid by 21st of July, or else the stay granted by this court stands vacated. This is matter on 22nd.
Obliged.
Number 17 adjourned, 18. Till number 18, Latif B for petitioner.
Appearing for petition, my lordship. The Honorable caused the interim maintenance of rupees 10,000, my lordship, which has been complied by the. The Honorable Court has filed an interim maintenance of rupees 10,000, which has been complied by the petitioner, my lordship.
You already paid. When counsel the petitioner submits the order passed by this court, they've been complying with the order passed by this court and paying the interim maintenance. No representation on behalf of the respondent. Admit post for final hearing.
Since 4 days, they are not appearing, my lordship.
Admit post for final hearing.
Number 19. Hearing on
Stay
inter-
granted is extended until further orders. Yes,
Till
ma'am.
number 19, S.A. Wajid Raghavendra K.N. for
No
petition.
representation. This is matters in the month of September.
Till number
22nd
20.
September.
Yes, ma'am. 22nd. Cell number 20.
In this case, appear for respondent, my lord. As per the instruction of the respondent, the petitioner was died, my lord.
Petitioner?
Died, my lord.
Petitioner died.
Yes, ma'am.
Petitioner is the husband.
Husband, my lord.
Give that. Then counsel appearing for the respondent submits that the petition is no more. The petition is dismissed. Dismissed as a.
Dismissed, sir.
Yes.
Cell number 21. Monisha.
Appear for the petition.
Memo is filed.
Please.
Take the memo. Take the memo from her.
Memo.
The present petition is filed, questioning the order passed by the court. Then criminal miscellaneous number
124.
124 of
24.
23.
23.
Dated 5/8/2023, whereby the court had granted maintenance of an amount of rupees
20,000
20,000.
original. But after an interim order, they are.
No, no, it's
20,000 is the
20,000.
order.
20.
Granting 20,000 as maintenance. When this matter came up before the court, as counsel appearing for the respondent submits that as is likelihood of settlement on 36/2025, this court had interacted with the parties, and both of them have agreed to amicably settle the dispute, and it is submitted that they'll come up with a joint memo. Now they have filed a joint memo before this court stating that the marriage solemnized between the petitioner and the respondent on 14/5/2. What is this there? 14/5/2995.
Hello?
Year 14/5/2995.
ಅದು change ಮಾಡಿದ್ದಾರ no? I had changed and sent it. I think they 1995. 1990.
It has to be.
Please.
No, marriage
I'm
solemnized
sorry, I
between the
apologize.
parties on
Make the correction.
12/14/1995 at GK Kalyana Mandapam, Banshankari, Bangalore, shall be dissolved in accordance with the judgment dated 26/5/2020, passed by the court of the 6th Additional Principal Judge, Family Court, Bangalore, and the husband will withdraw MFA number 2596 of 2021 by placing this joint memo before the present bench. The wife has agreed to withdraw all the pending cases against the husband and also has undertaken that they will not make any kind of claims against the petitioner husband. And in terms of the joint memo, in terms of the joint memo, they want this court to withdraw the dispose of the writ petition. having heard the counsels and having perused the joint memo that is filed before the court, and as the parties have amicably settled their disputes, and as they are going to file a memo before the division bench in MFA number, nothing survives for consideration in this petition, and accordingly, in the light of the joint memo dated so and so, the writ petition is disposed of.
Cell number
May make the correction with my lord's kind permission. Only one.
22.
I've already corrected.
Sign.
Yes.
You count.
Yes, next.
Sign, madam. Cell number 22.
And for the petitioner.
Respondent
wife, Your
husband, my lord.
Yes.
Lord, the statement of, I may be permitted to file the statement of objections. Or I may be permitted to file it in the counter, it may be taken up next week because the negotiations are also
Your
going on.
lordship, they have not paid the arrears, which is ordered even in the trial court also, they have not paid.
As for paying why you are filing the statement of assets, you have not filed before the trial court.
No, the trial court I have filed. I have filed, my lord, and because there are criminal proceedings also there,
Who is the petitioner? Petitioned is the husband
Petitioner is the
petitioner
wife,
before
your
the
lordship.
trial court is the husband.
of the.
Temperamental incompetency.
No,
Nego-
who is the petitioner here in 23?
In wife, your.
22. Oh. Wife is the petitioner.
Yes, your lordship.
What is the maintenance that is granted?
Lord, the
Your
temper,
lordship, 10,000 per month for the wife and 30,000 per year for the fees of the child, your lordship. Minor child aged about 12 years.
What is the interim order granted in this case?
Your lordship,
Is there any interim order in this? You are seeking enhancement of the maintenance.
enhancement of the maintenance.
What is the income of the husband?
1,05,000, your lordship, as per his
1 lakh,
assets and
1
liabilities.
lakh 513 salary slips have been produced. Not only,
So why the maintenance is only 10,000?
Lord, the thing, because both of them have not produced the assets and liabilities.
No, anyway, it's an admitted fact that it is your income.
Yes, my lord.
Whether she is working or not.
She's not working.
She was working, my lord, after the delivery, my
What is
lord.
the age of the boy?
12 years, your lordship.
You are not working now also.
No.
Why? What is your qualification?
She's a graduate, your lordship. On husband's insistence, she left the job. Later, she's not able to rejoin.
From how long both of you are separated?
From March 2022.
22. Yes. Why that amount should not, what is the maintenance that you have sought for?
We had sought for 60,000 per month for the wife and 50,000 per month for the child, your lordship.
Then what you'll do?
But that apart, your lordship.
No, what is this? First of all, there should be some reasonable request. 60/50 becomes 1,10,000. And
Your
the salary
lordship,
is
I'm filing the
1,05,000.
memo of calculation, what we are sorting for, your lordship, because
all this we cannot grant. What is the school fees of the boy? 30,000.
Not the school fees are
Granted
paid
by
by
the
the husband
school.
only. School fees, everything is taken care of by the husband.
So school fees you are ready to pay. Then what about the maintenance to the wife and the child? 10,000 is not, it's not an amount where they can't live with the 10,000.
Lord, she voluntarily abandoned the matrimonial house. And
That will be decided eventually.
yes, ma'am. So
Whether that was done or
He
not.
did not
anyway,
follow.
I have filed my statement of objection, my lord. It may be taken up for final hearing.
Nothing, no final hearing. What is big deal for a final
Next
hearing
week,
for this?
I am not seeking much time because
No
first time
time,
I.
there are no arguments in this required. You are earning 1,05,000. You're
1,530,000.
Okay, we'll take it as 1 lakh only. Let's deduct that 500 also. So in 1 lakh, why 10,000 only to the wife?
My lord, the other, my lord, from this, except the salary, my lord, I don't have any other income, admittedly. The statutory deductions, my lord.
After deductions, how much you're getting?
My lord, may kindly peruse, just
So you
pass
can
on.
tell the court how
Yes,
much you're
yes.
getting after the deduction.
Yes. My lord, the total expenses is.
No, I'm not asking you about the expenses. What is your take home salary?
60,000.
40,000 is deducted.
Yes, my lord.
There
Under
are
what?
bank loan for construction of the house I have taken. So then EMI, then petrol and other expenses, rent. I have made a rent, this one, my lord.
From that you can't, you have to tell the court what is
For
your
the
take
family
home?
only I have made, my lord. For living up, because
Home salary I asked.
60,000.
In that EMI is there.
EMI after that.
40,000 EMI.
Yes, ma'am.
Hmm.
Lord, I have to, I am the only son, I have to look after my aged parents also, wife and son.
You also
Lord,
have only one wife and one child. That also you have to take care.
Yeah, that's what I am telling, Lord. The parents as well as the wife and the child. Child income expenses, I am already taking care.
Agreed with orders passed in. I number 2. In MC number 249 of, why there are 2 MCs, both are filed?
Lord, the negotiations are going on for settlement, Lord, because she also doesn't want to leave. There is a temperamental incompetency.
We will, this is a 2020, this writ petition will dispose of. If you have a settlement, you can do it before the mediation center.
Application under section 24, Lord.
That's what I'm saying. Still the matter is pending before the court. You want to settle, you can settle before the court. Agreed with orders passed in. MC number 261 of 2022, dated,
33.
what is the date of order?
33, 2024.
33, 2022.
24, Your Honor.
2024. The wife is before this court seeking enhancement. The court had granted maintenance of an amount of rupees 10,000 and also directed to pay an amount of rupees 30,000 per year as school fees of the son till disposal of the petition. The wife has filed an IA under section 24 of the Hindu Marriage Act seeking maintenance of an amount of rupees 60,000 to herself and 50,000 to her son. The court, while passing this order, had considered the contentions of both the parties. That the court observed that though it is a case of the wife that he is earning 1,50,000 per month salary, she has not produced any material to substantiate her case. The objection to the petitioner husband shows that he is drawing salary of rupees 1,513,000 and after deducting various schemes he would draw 23,250. And on perusal of the objections, it is clear that some of the objections are voluntary and not statutory. The court observes that he can control the voluntary investments, deductions, and can retain some more amount and utilize it towards the maintenance of wife and the son. Court also observed that merely because the wife is a graduate and able to earn herself, he cannot be absolved from his liability on the said ground. And even if she is a graduate, she would be entitled to claim maintenance, and the husband is legally bound to maintain the wife. It is also observed that it is a contention of the husband that he is paying the educational expenses of the son, but not produced any document regarding payment of the same. Except some bank account statement, the wife has also not produced material authenticated documents to prove the expenses, and accordingly granted 10,000 as maintenance and 30,000 as school expenses. Land counsel appearing for the petitioner wife submits that when the husband is earning more than a lakh, the court granting when the wife and the son, the wife is not working and their maintenance cannot be taken care with an amount of rupees 10,000. It is submitted that the amount that is granted by the court is not an appropriate interim maintenance. It is submitted that the amount needs to be enhanced considering the requirement of the wife and the requirements of the wife and the son. Next para, land counsel appearing for the respondent, husband submits that though his salary is 1 lakh so and so, the after deduction his take home salary is 60,000. He has his parents whom he has to support, and and the court had rightly granted the compensation, and there are no grounds to interfere with the said order. It is submitted that the compromise talks are going on, and there is a likelihood of settlement, and hence the matter may be adjourned. Next para, having heard the counsels on either side, peruse the material on record. With regard to the settlement, this writ petition is arising out of an IA under section 24 of the Hindu Marriage Act. The matter is pending before the family court. If there is any likelihood of settlement, the same could be worked out before the trial court. Then coming to the facts of this case, the husband's salary is 1 lakh, and in the deductions and all, he's showing some more, the EMI and other things, and it is stating that his take-home salary is 60,000. He's living in a house which he bought on the EMI, on the loan from the bank, and you also do not have to pay any amount towards the house rent. When it comes to the wife, she has to take care of the accommodation and all other requirements. The parties are residing separately from 2022, and it is a case of the wife that though she is a graduate, because at the insistence of the husband, she was not. She stopped working. And when was the marriage?
Marriage.
2011.
7/11/2000.
When they got married in the year 2011, when somebody is not working till 2022, this court do not expect that immediately they'll get a job with just a graduation. The court was right on this count that it's duty of the husband to take care of the needs of the wife and the son. When he's getting an amount of rupees 1 lakh, granting an amount of rupees 10,000 towards the maintenance is not it's not a reasonable amount. Hence, this court is passing the following order. Next one. The order dated so and so, passed by so and so, is modified, and the maintenance that is awarded by the court is enhanced from rupees 10,000 to 25,000, and the husband shall continue to pay the educational expenses of the child.
Now, son's expenses I have been voluntarily paying.
That's what I recorded.
So it may be restricted to double 10 to 20, 25 will be.
Your Lordship, he has not paid
They are
school expenses.
No, he has filed the MC, or you have filed?
Yes, Your Lordship.
MC is filed by him or you?
Filed by me, my lord.
Then file a petition before the court to stay all further proceedings because he is not paying the maintenance.
Yes, maybe. Great respect, my lord. It may be, otherwise it will be on the higher side, my lord.
I thought it should be 30,000, but anyway, I made it 25. Now it can't be 20. Next.
Cell number 23, urgent 24, M. Veerabhadraya for petitioner, giving assessment.
The petition filed for the mandamus directing the trial court to dispose of the Dyer's petition.
Which year is the petition?
My lord,
To Malay.
may I make
From
What is this?
2024, kindly peruse this honorable court order dated moment. In spite of this honorable court direction, 5 times the respondent sought time for cross
When is the order?
My lord, order dated 16 January 2025. This honorable court order.
16 January.
Yes, ma'am.
In addition, so the family court shall proceed further in the matter irrespective of pendency. That is, the court only clarified, not that there is any positive direction from this court And one more thing is
That's
this
one,
court,
5 times it is listed before
whatever
the
it
court.
is, this court will not direct this matter to be disposed of because there is so
And
many matters.
every time from 2021, she is seeking time for
MCs
class.
of the year
No,
2022.
What class exam, what is the problem? Class exam at PW1. If it is class exam is completed, then matter will be settled.
Now the court will not even look
I'm
at your
facing
matter.
6 cases, Milan. It is not a one case. I'm facing 4 criminal cases.
We have to.
See,
we
because
have
the
to
respondent
deal
is
with
the advocate. No, she is an advocate. See, because she is advocate, she playing all these games. At least let your lordship fix some time. I'm not insisting that 3 months or whatever the time your lordship is to say. Let it complete.
This court has already issued specific directions to the family.
Of course,
courts.
now present.
Please understand what
Yes,
I'm
madam.
telling. Issued directions are they cannot take up any other matters except 2019 matters. By December 15th, all the family courts in Bangalore, they shall complete 2019. They shall not take up any matters other than 2019, till 2019.
I'm relaying dishonorable coordinate bench decision.
That is not practicable. We have to look at
Thousands
of matters are
earlier
pending.
proceeding officer was dead. Now proceeding officer not giving time. I'm telling-
Petition, they will not take up your matter. That's what I'm telling you. No, I cannot give some order contrary to what is already directed to them. The present petition is filed saying so and so, so and so. The MCs of the year 2022, there are much older matters in the family courts. And now the courts are taking up the pendency from the older matters until 2019 only. The courts are concentrating and trying to dispose of by this December. In those circumstances, there cannot be any direction to the family court to take up a matter which is of the year 2022. Accordingly dismissed. Next.
Number 25. Yes, Venkat Subbarao for petitioner. Anita R for respondent.
Yes.
Petitioner is the respondent.
What is the impugned order?
The impugned order Annexa A. Where, my lord, we sought for, my lord, the appointment of a court commissioner, my lord, to record the evidence of, my lord, the petitioner through the video conference. My lord, petitioner, my lord, along with the children, is a resident of US, my lord. She is unable to come here on account of her employment. And also that, my lord, children are.
Who filed the MC?
The respondent.
I have filed the MC. my
MC
lords.
for?
Dissolution of marriage.
No, we will fix some time frame. That time she can come. We will not ask for, we can't pass this order. If she can come, we'll ask the court to, conduct the cross-examination or whatever it is in a time-bound manner, but not through VC. That's not possible.
She's unable to come because of, my lord, employment. But
She will be coming at, what is this, which year, this MC of 2019. Now, if you go, if she can come, holidays will be there for everybody.
My lords.
What is her job? What is she doing?
She is a software engineer.
A software engineer, not that they will not
The
get
visa on which, my lord, she has traveled there. My lord, the number 2 is, my lord, she can't leave the children. There's no one to look after
My lords.
children there.
My lords,
But
children
father
are
who was alone.
Almost major, 17 and.
No, that's all right. That's
And
right.
also, my lords, we had filed an application seeking for visitation rights. And even that, she's not allowing the children to speak to the father on.
Where he
audio,
has not,
video,
he has to
nothing at
travel,
all.
my lord, to US. We
No,
can't
even
bring
no
the children.
audio,
But talking
video,
about
she's
the
not.
travel, they can talk over phone, they can have a video
That's
call.
permitted, my lord. It's not.
My lords, and
she has
one-
not stopped.
When the
all.
VC is permissible for a cross-examination, for seeing the children on.
Always not interrupted, my lord. Not interrupted.
She did not
My
allow at
learned
all,
friend is
Your Honor.
deviating from the topic. Let me make this clear, my lord. The two children, my lord, there's no one to look after. But the father was, my lord, well alive. My lord, he was also in
Because
India.
I cannot pass such an order. I have already passed several series of orders where I said that unless and until our VC rules are formulated completely, though those were the rules for the during that COVID period, unless and until they were again formulated, there can't be any direction to examine a witness, that to a prime witness, because she is the
Contesting this.
witness. There can't be that. She has to come. You can tell the court when I'll adjourn this matter. She can tell the court when she can come. I'll direct the family court on a particular days and also to them to complete the cross-examination.
The work visa upon which she is, my lord, staying there. doesn't permit it to come back, my lord, India, number one. Number two, my lord, there is no one to look after. My lord, father who was alive, my lord, who was in India, was also, my lord, abroad taking care of the children. My lord, he was also a power of attorney.
How
my lord,
long
so
they are
long.
in US?
My lord,
From how long they are in US?
from almost 9 to 10 years, my lord, she is there.
And you know, the children of 17 and 18 years do not require a mother to take care of them
No, correct. My lord,
when they come to India.
no, my lord,
My lords, we seek them
no,
to
my lord,
come.
the children, my lord, cannot come to India because, my lord,
They don't, they need not.
they are
Let the mother
studying
come.
there. No, if
the mother
she comes, my lord, there's no one to look after them,
That's
number
what I'm
one.
saying. For children who are staying in US, who are 17, 18, who live on their own without the parents' support, they don't require somebody to take care of them and to monitor their activities.
They
Please,
have, no,
please
these
find
children
out.
are still, my lord.
Please find out from your client when she can come. Let her give the dates. We'll issue a direction to the family court to complete the cross-examination at that time.
Father, my lord, who was there, he was the power of attorney, he prosecuted. Unfortunately, my lord, he died. So that's how, my lord, she's unable to, my lord.
This is
now.
matter on Thursday. By the time the learned counsel of the petition shall get specific instructions when the wife is going to come to India. So for subjecting herself to the cross-examination. Yes.
My lords, one submission, my lords. From the emails what they have exchanged, the respondent is before the court, from what they have exchanged, it is only the matter of property that she is concerned about. They've got some 4 properties. All the documents are in the locker and she has the keys. If she wants to, the husband to sell the property and give her the money, which is ready. And if she brings
That's the only
keys,
thing. Otherwise, she's ready for divorce.
she is ready.
Is it so?
Yes, my
I
lords,
don't know,
she has sent the emails.
I don't know.
Anyhow,
If
it's
they
coming
have
up.
some emails,
It's coming
my lord,
up. No,
it's
no,
not
1 minute,
addressed to
1
me, I'm
minute,
sorry.
1 minute. Not admissible when parties want to settle. Why not?
Efficient.
So, any of this matter is coming on Thursday. In the meantime, please talk to him
Yes,
also. And if that is the case, then we'll explore that possibility.
Yes.
So she need not come at all.
So
So
if
that
she
even
comes, only if she comes, because the keys are with her. And unless she comes, it's not going, because
bank locker.
2 properties are in joint names and 2 in individual names.
No, that's
And the
whatever.
father is ready to give.
By the next date of hearing, please explore all those
Yes,
possibilities
yes,
and you can
yes.
submit before the court. Yes, next.
Cell number
Next
26.
Thursday, my lord, sir.
This Thursday. You want it next Thursday?
Yes.
Yes, next Thursday.
My lord. Only weekends I'll be able to establish contact.
Next.
17-7. Cell number 26.
Interim order may kindly be continued.
Interim order only granted is extended till then. Yes.
Ravindranath K for petitioner.
Lord, it is IPF for the petitioners. Lord, the application file came to be filed. Lord, it's wife filed a divorce petition before the trial court. Lord, I being the husband, Lord, appeared, filed a statement of objection.
What is impugned order?
Lord, impugned order that I filed application order 12 rule, Lord 6 for Lord consent decree. Lord, they also filed a memo to stating that let it be application may give a consent, Lord, divorce. That, my lord, the learned trial judge accepting the, my lord, even application as well as memo filed by the even wife. So no objection for, my lord, allowing the applications and giving the divorce. My lord, the learned trial judge kept the, my lord, family court, kept the IA in abeyance and posted for evidence without passing any order. That is the
Where
impugned
is
order.
that?
Kindly see, my lord, page 40, my lord.
Page number?
40, my lord, 40. Annexure, my lord, E. Page impugned order is at 40. Both the parties absent, no representation. Orders on IA number 6 is deferred and the said application is kept in abeyance. Parties are directed to lead.
Why you were present?
No, that is a posted for orders.
Both parties absent.
No. That particular day matter was posted for orders.
Where is the counsel for the respondent?
No, they served their because they wanted to not. They already filed a memo for no objections. Sir. They already served the copy.
Finally, this order has to be passed. There is nothing that we can do. There is no interim order in this. Please serve a notice on the respondent.
That's she's already served, my lord.
Oh, it's already served.
Served, that's.
Who served?
By through court it is served, my lord. By this honorable court notice it is ordered.
Not appearing.
Not.
The husband is before this court questioning an order passed dated 7/12/2024, where the court had deferred the hearing on I number 6 and kept the same in abeyance and directed the parties to lead evidence. Then counsel submits that.
Page number 28, annexure C.
28.
Page C, annexure C.
Submits that both the parties have consented for A mutual consent divorce.
No, my lord, I filed application, that is a consent decree. Then they filed a memo for no objections. D, annexure D, my
Filed
lord,
a,
page
he
30.
filed a suit for seeking, he has filed a MC for divorce. Wife had filed a petition.
Filed petitions.
Saying that she has no objection to grant the divorce. That is I number 6.
This is husband filed, IA filed by the husband.
Hmm.
Lord, memo filed by the no objection by the petitioner, that wife.
Is filed by the husband seeking a consent decree. And the wife has filed a memo saying that she has no objection for the same. It is a grievance of the petitioner that in spite of the same, the court had kept that particular IA number 6 in abeyance and posted the matter for judgment, for evidence. Notice to the respondent is served and no wakalat is filed on her behalf. Considering the fact that the IA number 6 is pending, where both the parties are consented for a decree of divorce. Which family court is this? The first additional principal judge family court shall dispose of IA number 6 within a period of 1 month from the date of receipt of the copy of the order.
No, it is only consent. This court can also, my lord, pass orders.
No. Yes. Next. Disposed of.
Cell number 20. 27. Aditya D for petitioner. Arun Govindraj for respondent.
My lord, on the previous date of hearing, a clarification was sought with regard to documents that have been filed by the respondent. I would like to make those clarifications. So first and foremost, document number 1 and document number 3 are already a matter of record in the assets and liabilities. They are not a fresh document that has been filed. So let's take these documents head on. One statement that has been made in document number 5 is that there is a bonus that has been paid in the month of May 2024. This, according to the respondent, is an anomaly. It most certainly is an anomaly. It's a bonus and it's variable pay. Therefore, it does not form a part of the salary statement. Doubling down on this, in document number 3, which is on page number 3 provided by the respondent, they have highlighted before this court that the CTC is 25,80,004. That's correct. But if one turns the page, my lord, one sees the breakdown of the CTC. In that, we see there are deductions with regard to provident fund, something that's not part of salary. Next, we have notional value for insurance premium, again not counted as part of salary. Variable pay is not part of salary. When these figures are deducted in a given month, the amount that comes is 1,21,000 odd rupees, which is the figure that has been put forth as the salary of the petitioner herein. And then I would like to also look at document number 4, my lord. Document number 4 has been listed as the payments that have been made by the respondent towards Master Ayansh's school fees. I'm not able to decipher this document, my lord, because it says a certain amount of money has been paid by Ayansh Rator. This, where has it been paid towards the school? There's no context to this document. I do not understand it.
Mr. Govindraj, what are this 5?
Lord, these are payments made by the mother directly to the school.
But where?
Lord, my learned friend, I think, it's trying to deflect the issue. Your
No,
lordship.
I'm not.
Sorry.
And I will explain why.
Kindly allow me to make my
No,
submission.
don't misrepresent what I'm trying to say, sir.
I'm
I'm
sorry, I
asking a
think-
very simple question, my lord. It says that these are amounts that are to be paid to the school. This is a financial transaction. Where is the school's name in this, my lord?
Lord, the question before the court the other day was, an affidavit is filed before the family court declaring the take-home salary as 1,21,000.
That's correct.
While the petitioner had a document in his hand which said his salary was 2,15,000 rupees a month.
It's
No. Now you have heard what is his submission
Yes.
with regard to 2,15,000. What do you say on that? He says the basic salary is 75,250. Allowance that is flexible is 93,267. He shows 16. Then after that, after provident fund,
Deductions,
gratuity,
yes.
everything is
14,000. Deduction is 14,000. Subtotal B is 14,000. Apart from that, variable pay is 32,250. Total is 2,15,000.
Yes,
My lord,
because it adds C.
May I make this request, my lord? 31st of July is when the affidavit of assets and liabilities is filed. My learned friend has not filed the salary certificate for 31st of July. It's only filed for April, May, June. If he files a salary for July and August, my lord, your lordship, it will become, we'll be aware, my lord, how much he's received.
On the contrary, my lord, they have said gross CTC is A plus B plus C at the bottom of the table. It is my submission before this honorable court that C cannot be considered.
No, instead of complicating all this.
Yes, my lord.
You have your July and August, June and July, your salary slip must be there.
I can procure it. It's not.
You can place it.
Yes.
So we don't have to go into the other issue.
I understand, my lord. My lord, I would also just like to put forward one simple point. The rationale that has been used by the lower court for passing this particular order, which is being challenged now before this court, which was a grant of 25,000 rupees to the child as well as 20,000 rupees towards litigation costs. Now, the rationale that was used was that both the petitioner and the respondent earned roughly the same salary. Now, the difference between them is give or take of 30,000 to 38,000 rupees in salary. One is about, I am about 1.21.
Question that order.
Right. I'm questioning the maintenance, but I'm trying to understand the rationale of the court in order to just put forward why I am going into the nitty-gritties. I earn 1.21 lakhs. They earn about 1.6 lakhs. Now, normally, if I earn 30,000 rupees and he earns 60,000 rupees, the rationale of the trial court will not be that we earn the same amount of money. The difference between the two is about the same, between 1.2 to 1.6 and say 40,000 to 60,000 or 30,000, 60,000, it's about 30,000 rupees difference. The reason being that there is a threshold in society that exists. When you earn about 1 lakh more, you are earning a lot more than the general public that exists in this country.
Not going to all that.
No, so the reason being.
Let's not go into all those ratios. Let
All
me
right.
tell you. Now you are earning 1,25,000, as you say, and the wife's salary is 1 lakh.
Yes,
then
ma'am.
the son is with the wife who has to take care of his needs.
Yes, my lord.
So irrespective of what it is,
Yes.
you are like with your salary, you can contribute what the court has given.
Absolutely, ma'am. But I have one counter submission to that, my lord, in that the liberty is given now to the particular person who's in custody of the child to come up with an estimate of the costs of the child. This is understandable. Every father must also contribute to the taking care of the child. But that does not give leeway to create inflation of costs. It is a submission before this honorable court that I believe the total amount.
Come to the impute order.
Yes, ma'am.
Where is the petition? Yes, page number.
26 para 14 is a consideration.
Yes.
Yes.
Paragraph 14.
Yes.
Yes, madam. So the governing rationale over here is that there's some rough parity between the two parents. Therefore, the two parents should equally bear the costs of the child. What is the contention of the petitioner is that while that's absolutely true, it is the contention of petitioner respondent has inflated the costs of the child and it does not come up to
What is his
50,000.
age?
His age right now, why am I that much? He would have turned.
He's 8 years old. Turns
Yes,
8 next
he's-
month.
He's turned
So
8.
what is his school expenses?
2 lakhs, my lord, is the school fee.
Yes.
Yes.
It is good, 2 lakh per month, per year.
Yes.
How much it comes to per month?
Per month it'll be 2 divided by 12. So let's say it's 10. So it's 20,000. 20,000 with adding about another thing is give or take, it would be come up to about 21,500, my lord. No, it's a little more.
16,666.
No, how?
It would be-
Just for
it would
2
be
lakhs?
less, not more. It would be 16,000.
No,
16 to
no.
18,000.
What I'm saying is that the cumulative amount that has to be paid with everything else.
No, no, no. We are only on the educational expenses.
Oh, just the education is
So
60,000.
education expenses,
Yes, ma'am.
16,000 and odd is coming. And where are they residing?
They are here in.
They're not residing
They're
in
not,
any,
no.
they're residing in a rented premise. Then both the child and the wife are residing.
Yes, that's
Then for him, there are other several expenses.
That's
which
correct,
are-
ma'am. Yes.
In my view, the court had rightly granted because the court has not given any other educational expenses. Extra educational expenses. Everything is amounting to 25,000.
It is also we would like to submit that also 8,000 rupees is being given towards a premium for future educational expenses, which has been.
How it will meet his day-to-day expenses? What
Yes,
is this
that-
going to come after 18 years?
Yes, my lord, that is true. The 8,000 rupees doesn't go towards the payment of current expenses, but it is for future educational expenses, and it is an amount the father is indeed paying for the child. And it is something that is coming out of the father's bank account every month towards the education of the child.
No, I know,
Albeit
but nobody is asking you to pay that. That's your choice. You have made.
Yes, but it is towards educational expenses. I would just like to put forward that where even though it has been postponed to a period of time when the child become post 18, it is towards educational expenses. I would also just like to highlight one more thing before this thing. In the assets and liabilities of the respondent, for the year 2020 and 21, they have deducted house allowance in their income tax, but they cohabited till 2023 April. It's just a point I would like to put forward that rent was not paid, but house allowance has been deducted for 2 years while she cohabited with the petitioner. This is just one point I wanted to put forward.
But I have only one request. On the last occasion, document number 7, I brought to the court's notice, undertaking given by the petitioner before the family court. He will stop sending emails to the respondent wife. My lord, every night he keeps sending emails. After the hearing before your lordship on 2nd of July, another email at 11:30 in the night, my lord, he sends. After hearing before your lordship, he says, you're going to go to court, you do what you want, I'm not scared.
Why there is no respect to the court orders from your client? Why is he doing all this? Give it to him.
I'll place it on record with copies, sir.
I do not know how I can be a drunkard.
At 11:30 in the night, my lord, same night, on 2nd of July.
Why he feels like communicating after only 11 o'clock?
All communications after 10 p.m. And it goes on till 1 o'clock, 2 in the morning.
Please let me talk to my client, my lord.
Undertaking given to the court.
Talk to him and I'll pass orders on this tomorrow.
Yeah.
Tell him that this is not the way he'll go ahead.
Sure.
If they're not liking each other or if they want to be separated, whatever it is, there is a way. All educated people, this is not the way you go.
I agree, my lord. My lord,
Find
but
a lady like this.
my lord, I would also like to highlight that there is an order for visitation rights. My client has not got any opportunity to visit the child.
I'm sorry.
This is what is
We have,
happening.
my lord, we have been complying with the visitation. When he said, I'm not going to pay maintenance, she said, until you comply with the court order, I will not comply with the court. You comply with the court order, I will comply. Visitation was being extended every week. He says, I will not pay maintenance. Yes.
As you know, this is a chain reaction. Husband does something, the counter, the wife will do, again, husband will do something else, and they'll be, in this cycle, they'll be going on. And there is no end to their problems. Somebody has to be wise enough to, please talk to your client,
I
come
will.
back, tomorrow I'll pass orders.
All
Then
right.
this also for judgment in the top tomorrow.
Much obliged.
Yes. This number.
List number 2. Serial number 1 urgent, serial number 2, list number 2, serial number 2, Kallegowda SK for appellant.
That is,
Kindly reissue. Last occasion, because of 4/6, we took steps.
non-compliance of office objections raised on process memo, so and so notice to R1. A week's time is granted for complying with the office objections, or else the appeal shall stand dismissed without further reference to the court.
Serial number
Next.
3 urgent, 4.
List after service of notice.
Yes. Serial number 4.
In this matter, you were submitting Janardhan Reddy, non-depositing of 50% of the award amount.
That is serial number 3.
Morning he has mentioned, that is with respect to 3, not 2. I think I have recorded for 2.
No.
Isn't it? 3 only it is recorded? Yes. Yes, next 4.
Serial number 4. D. Vijay Kumar.
Yes, Mr. Vijay Kumar.
He wants to.
You will submit in the morning when the time of mention, sir. Not there when the matter is called. This is matter. After to list this matter on 15th of July. No representation. Yes.
Serial number 5.
A week's time. Default order.
Serial number 6.
In this case, Your Lordship, there is already stay granted the Honorable Court on.
List the matter after service of notice.
Yes.
X 7.
And stay may kindly be till this date and
Why this stay for this date?
as I could see from
Let
the.
it, if there is a yes, whatever granted, earlier order granted is extended till the next date of hearing.
Obliged, Your Lordship.
Next 7.
Serial number 7.
List after service.
Respondent, copy of memo not
Serial
furnished.
number 8.
No representation for the appellant, list for dismissal tomorrow, so that they will come, will ask you to serve the papers. Yes, 8.
Serial number 8.
A week's time, default order. 9.
Serial number 9. Serial number 9. P. Chandrasekharaya for appellant.
No representation for dismissal tomorrow.
May I
Then
make
10.
one submission, my lord?
Hearing on interlocutory application. Sanjeev BL for appellant. Sridhar V.
My lord, owner's appeal, my lord, I am a respondent claimant. I
Not
preferred
audible.
an IA for permitted to withdraw the amount of.
No, it is there. So Shripad V. Shastri sir, your audio is muted. Court can't hear your voice, sir.
My lord, now I am hearing. So
You're
I-
not audible, Mr. Shastri. List is matter day after tomorrow.
Number 11. Cell number 11.
Yes.
R. Shashidhara.
Claimant appellant.
Notice.
Notice.
Notice has to come.
Notice to the respondents.
Cell number for admission. Cell number 12. Patel D. Karegowda.
Arising under WC or MBC?
That is
MBC.
death case.
MBC.
Please.
Shall we admit, or it's a likelihood of
It has to be admit or.
It has to be admitted, my lord.
admit call for the.
There is no policy in that.
Admit post of
TCR.
final hearing, call for the, TCR is already there, yes. Yes, next hearing.
And stay, interim order stay has to be extended.
Why in this also limited stays, why it will be there?
Because I am the financier, my lord.
Uh,
Liability is fixed upon the financier, financing
No, in
company.
all these matters, the stay is on the condition of so and so, where is the question of extending will arise?
Please, please.
Yes, next, 13.
Cell number 13. Latur Suresham Latur.
Yes, Nirmala, this admit post of final hearing,
Yes.
TCR.
Number 14. 14.
Where is Mr. Samprati?
Karnataka P.
There's a delay of
Samprati.
109 days, will condone on condition?
No, my lord. The reasons are very bald. They haven't stated anything. Anyway, the claim petition was dismissed.
We can hear the matter itself and then no representation for the petitioner. Or we'll admit this, no, but there's delay. List this matter on 12th of August.
12th of August.
Yes, 15.
Cell number 15. Raju, yes, for appellant.
Admit post of final hearing, call for the DCR.
With your lordship's kind leave,
This is I think the morning it is adjourned to
may I make
tomorrow.
one
And cell number 17.
my lord,
Yes, in final hearing matters, anything pertain to Sriram General Insurance?
my lord.
Today you have, which are the matters?
Third list.
No, in final hearing I'm asking, in the second list.
That in this matters, final hearing.
Second list.
Somewhere
If it is there,
Pradeep-
my lord, we will assist.
National Insurance.
What you can do is, except if you can give the
The
number.
Sriram Insurance Company is there, we are ready.
Huh?
We will assist the court.
No, just take out each bundle. 17, which is insurance company,
17.
National Insurance.
National Insurance
National
Company.
Insurance.
17 lists the matter on 5th of August. Then 18, which is insurance company.
Sriram General.
Then keep that matter aside.
Side.
Password.
18, then 19.
19. Nagaraj Reddy.
Claim petition is dismissed.
List this matter on August 5th. Next 20, which is insurance company.
Cell number 20. Chandrasekhar Ayyavi.
Company.
Which insurance company? That is
And
national.
inform that advocate also that it will be taken up.
That is.
National
No, this
Insurance.
matter where Sriram Insurance Company, inform that advocate also.
Who is the advocate?
Give him the file, that 18 file.
Will give.
Next,
Cell number 20 is National Insurance Company.
list the matter on 6th of August.
Cell number 21.
Yes.
United India Insurance.
This on August 11th.
11. Cell number 22. GM Ananda. Cholamandalam General
This
Insurance.
is 12th of August.
Cell number 23.
What about this? Girish B. Ballare. He must be appearing for the insurance company.
Yeah. No.
No.
He is the claimant.
He's a claimant's counsel.
Insurance company.
Hegde Mulkanda, he appears for Sriram General?
No.
United
So
India.
then list the matter on 13th August. Then 24.
24.
I am for the respondent KSRTC, my lord.
So this
ready.
matter on 13th of August. Then 25.
Cell number 25. Janardhan Reddy.
Then other it appears for Sriram General? No. This matter also the same day.
13th August.
Next come to this court, this one.
With your lordship's kind leave, my lord, I am extremely sorry, my lord. Serial number 4 in the second list.
Specifically asked them not to mention this. Who mentioned it?
My lord, I am.
100 times I
I
told
moved
you.
this matter. I moved this matter on many occasions. I was held up in portal number 6, my lord. By the time I log in, by that time next case was called, my lord. I am very sorry.
You're doing the same mistake instead of telling 100 times, sir.
I am very sorry, my lord.
Yes.
The matter is very urgent, my lord.
Yes, what about this?
Serial number 4, my lord.
Number 1. Number 3.
Settle.
Hmm.
Serial number 12, my lord. 50,000.
Serial number?
12.
Serial number 12.
Serial number 12. Our act ಕಾಯ್ಬೇಕು.
ಯಾವ್ದು?
50,000.
Huh?
50,000.
1 minute.
Which serial?
12.
12, when counsel for the insurance company submits that they are ready to settle this matter by paying an amount of rupees 50,000.
50.
50,000. Place this matter before the Lok Adalat on Thursday.
And
Then
16 and 1601.
16 and 16.1.
Case, my lord, there is a pay and recovery order. Retaining that, my lord, we are ready to pay in addition. The tribunal has awarded 17 lakh and that, my lord, 2,55,000 in first matter, second matter,
1 minute, sir.
2,60,000
In addition, this is an addition.
in addition.
2 lakh first matter
2,55,000,
and the other matter
2,60,000. Pay and
60.
recovery 260. Pay and recovery order has to.
That is already there.
It is the same order.
The When counsel appearing for the insurance company, Mr. B.C. Sevenagowda submits
Please.
that the company is ready to settle this matter by paying in 16, by paying an amount of rupees 2,55,000 in addition to what has been awarded by the tribunal. And in 16.1, they're ready to pay an amount of rupees 2.60 in addition to what has been paid by, what has been awarded by the tribunal. Is these matters before the Lok Adalat on Thursday?
Global ಅಂತ ಅಲ್ಲಲ್ಲ ಪ್ಲಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ ಹೋಗ್ಬಿಟ್ಟದು ಅಂತ.
I didn't say interest.
No, that's the reason, because we have calculated the interest.
That's why I didn't say interest.
Please,
In
global.
addition to
Please.
this amount. With interest, I didn't say.
No.
Yes. Next, any other matter, Mr. In 16.1, memo is filed seeking dispensation of notice to R1. Same is taken on record and dispensed with.
In
Then
16.1
IN
also.
25, delay.
In 16.1 also, my lord.
16.1 only, I am looking at the delay. IA number 1 of 25 to condone the delay of 250 days. On the condition that they'll not be entitled. So the condition that they'll not be entitled for the interest for the delayed period. Then in 16 also, notice to, then you have to file a memo.
I filed process and the memo for dispensation also, my lord. In first matter also.
See, memo for dispensation to respondent number 1. Memo is taken on record and notice to the respondent number 1 is dispensed with. Any other matter?
In first matter, delay.
Serial number 5,
okay.
cause list number 3. It's an MFA matter. We tried for settling. We're not agreeing. They're giving really less amount. But the matter is posted on 18/9 for further hearing. So we just want to put forth our Putamada MFA 2895 of 2020.
Which number,
It is
serial
posted for argument, madam. If you are ready, please address the argument.
No, we are not settling for the amount that they're proposing.
When the registry places that kind of a caption, what they will understand?
That's what.
Told them specifically
Yeah,
not to
we have
do it.
requested several
Call the
advocates.
Registrar Division.
They said that, madam, it is referred to local law, therefore we.
Correct.
Let us say we have not brought the file. That's what I
Correct.
got. Though I have requested some people. But if they have brought the file, madam, we can.
ಇಲ್ಲ ಸರ್ ಇವತ್ತಾಗಲ್ಲ ಅದು. I thought it is for ಲೋಕ್ ಅದಾಲತ್. ಅದಕ್ಕೆ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಕ್ ಬಂದೆ.
There are other matters which can be settled or
Any day.
what we do is tomorrow you are okay with it? Then we will remove this caption.
That's serial number 21, my lord.
They should be, they're not using the brain at all.
Serial number 21, my lord.
List all these matters,
ನಾಳೆ.
list the remaining matters tomorrow and tell them to remove that caption. And matters of.
Serial number
Serial
6.
number 21 is
Also there, my lord.
Which one? Serial number?
6.
21.
Serial number 4, my lord. MFA 8274 by 2019.
One minute. Serial number?
4 in third list. The owner appeal is 8274 by 19.
List along with so and so and delete from this list. It has to be deleted from this list. It can be.
No, it cannot be settlement. Owner appeal is there, liability.
But I'm saying it has to be deleted.
Yes, ma'am.
Delete from this list.
And next, my lord, serial number
is 3.
28.
20?
36. ಎರಡು ಮಾಡ್ಬೋದು.
Is a contributory negligence on the
28 also,
78.1%.
it is submitted, there is no likelihood of settlement, delete from the list.
Serial number 21, my lord.
Serial number 8.
Serial number 8 of this 3. I'm ready both of.
Ready? What is the amount?
But they saw that 3,97,000 is granted.
1 minute. What they sought?
3,97,000 is granted.
It's a case of injury.
It's a case of injury.
What are the injuries?
Head injury, my lord. Head injury 78.1% assessed by the doctor, which was not considered by the tribunal as a future prospect. Future income has not been
How
taken.
much is that?
My lord?
Disability is 70%.
78.1%. It is clearly come in the judgment, my lord. And even.
It is 78.1%. To the whole body.
Yes.
So in that case, how much it comes? What is the income?
I'll look into that.
50,000 per month he was earning.
Any document on record?
I think it is a tribunal, it has been
Then
produced.
both of you look at it tomorrow, this same will come tomorrow.
Please.
It will come tomorrow. You
Yes,
also
my lord.
make your exercise.
Yes, even serial number 36 also, my lord.
Ah,
It is there, my
Tomorrow.
lord.
ah.
That is also tomorrow.
No,
Tomorrow,
no.
everything will come tomorrow.
Can we?
Serial number 21 is matter settled before the Lok Adalat. My lord.
ಏನಿಲ್ಲ ಅದರಲ್ಲಿ ಇನ್ಕಮ್ ಆಡ್ ಮಾಡಬೇಕು.
That I will assist.
Let them, tomorrow I'll take up. The entire list will come tomorrow.
We will close the matter. Tomorrow we will.
Yes.
Okay.
Okay.
Please.
Even doctor said.
Even more.
The matter moved at end of the list. Okay.
Hello, court officer. Madam, court officer. Hello, court officer.
Court officer? 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 Court officer?
Court officer? Hello, madam, court officer. Huh? Hmm.
Court officer? Court officer?
ನಮಸ್ತೆ ಸರ್ ಹೇಳಿ ಸರ್
Court officer?
ಮೆಮೊ ಮೂವ್ ಮಾಡಿದೀವಿ ಸರ್ ಸಾಹೇಬ್ರೆ ಇದ್ರಲ್ಲಿ. ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮತ್ತೆ ಯಾರು ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್
Court officer?
ಆಯ್ತು ಸರ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ನಿಮ್ಗೆ ಫೋಟೋನು ಕಳ್ಸಿದ್ದೆ ನೋಡ್ರಿ.
Court officer? Court officer?
Court officer. Madam, court officer.
ಗೊತ್ತಿಲ್ಲ. Court officer? Court officer? Court officer? Court officer? ಹಿಂಗಾಗ್ತದೆ ಒಂದು ರೆಗ್ಯುಲರ್ ಆಗಿ ಟೈಮ್.
Court officer. Court officer. Court officer.